common question that we hear from our clients is, will my case go to court? You might be surprised to know that the majority of the cases will not ever go to trial. But what we don't know is which case will need to go to trial or which cases will settle, so you have to plan for the possibility that you will end up in court. Let's talk about why a case might settle instead of going to trial and what that process would look like. There are many reasons why you and the insurance company might want to settle instead of going to trial. First, there's the jury. There's uncertainty when you pick a jury. You can pick them, but you can't control them. They might not like the witnesses. They might not believe what the witnesses have to testify about. There's also your public image. Will they like you? Is there something in your past that might affect what they think of you? And will they believe your testimony and the cost that has to be incurred to take a case to trial? There's filing fees. There's fees that you have to pay for depositions. The mediator has to be paid, and all of that adds up. So those are things that we have to consider, whether a case should be settled or you should go to trial. We have to be fully prepared to go to trial if that is necessary. So with our cases, from day one, we here at the law offices of James Scott Fearon, we will begin gathering information and building your case. There are 3 things that we must prove to win your case: fault, causation, and damages. Number 1, we have to prove fault. We have to prove that someone did something wrong, and that is called negligence. We then have to prove that that negligence or that wrong committed by someone caused you to be injured. That's called damages. The third point is causation. So you have fault of the person who caused you the harm. The causation is they caused the injury to you, and because of that, you're entitled to compensation for those damages. Those are the 3 things that we must prove to win your case. After we have built the case and you have completed your treatment for the injuries that you sustained, the next process is to gather all that information together and submit it to the insurance company. We call that a demand package. And along with that, we present to the insurance company an amount that we believe they should pay you for the damages you sustained, your damages being injuries. After the insurance company has had a chance to review the demand package, the next step will be that the attorney and the insurance adjuster negotiate to see if they can agree on the amount of compensation you should receive. At this point, there are 2 possible outcomes. 1, the parties all agree and the case settles for the amount of compensation that was negotiated. And 2, if the parties do not agree to a settlement, then the case can proceed to trial. As you can imagine, handling a case can be very complex. But we here at the law offices of James Scott Fearon, we have the resources, we have the knowledge to help you through this process. Some of the ways that we can help is to determine who was at fault, gather your medical records and bills, investigate the scene, hire experts if needed, negotiate the case for you, and if necessary, go to trial. For a free case evaluation, call us or look us up online. Let us deal with the legal part of your case while you focus on getting better.